Can I beg your indulgence for a minute or two with a legal point and problem about the Leveson inquiry that others have not strongly made much of? Criminal, civil, legislative and public inquisitorial processes into the same issues, same people, same corporate bodies and same profession become a disproportionate and damaging phenomenon, prejudicing each other, prizing open and catalysing evidence, self-fulfilling and self-perpetuating the different and overlapping strands of problematisation. Such a situation is seen as unlawful and unacceptable in international law. It's called nils alibi pendens. In my opinion, it was legally and morally wrong for the Leveson inquiry to take place with all these other things going on. Enough fuss is made about journalists prejudicing the right of other people's fair trial. I don't think it was right that politicians, police officers, alleged victims, lawyers, academics, and even judges should have indulged in what I saw as a mad frenzy of impeding justice and demonising reporters, journalists, their editors and their sources. It really was a disgrace that such an inquiry should have proceeded on the premise that all the allegations that the Metropolitan Police were investigating had been factually proved. The 47 people arrested have a right under Section 6 of the Human Rights Act to have their presumption of innocence respected. And I think it's a tragedy that it's very unlikely any one of them will get a fair trial in this country, whether tomorrow, next month, next year, or the year after. Can I now take you to the cold, dreary and rather forbidding age of the ocean for my view on something occupying most of our minds at the moment? I want to deal with the issue of what happens next. I can't imagine for one moment that Lord Justice Leveson's report is going to be some kind of jurisprudential Prozac or Valium for British journalism. I'm told it's likely to come with a little dab of statute, a little touch of cyanide coated in carrot cake. Well, that can't be too bad, can it? I suppose a little compromise, something peculiarly British. Not high tea, but low tea, not salmon and crayfish between the rocket and watercress, but thin slices of old cucumber and organic tomato. A foghorn to take us back to the 1970s and early 1980s, when the great Sir Harry Evans had won that vitally important ruling at the European Court of Human Rights, that the Sunday Times could not be in contempt of court for campaigning for limbless child victims of thalidomide while there were non-jury civil court proceedings going on. I was told then by our country's finest lawyers, judges, politicians, academics and journalists, we're going to get a statute to put things right, to give you all the President's men in New Fetter Lane, in Bouverie Street, Gray's Inn Road, Fleet Street, Farringdon Road and Dr. Johnson's Gough Square. Just a dab mind, nothing more. You're going to get a contempt law that's fair, balanced and reasonable, public interest and all that. For the first time, Parliament's going to legally protect journalists' sources, and you'll be able to tape record court proceedings, though never broadcast them. Lucky you, they said. And we got the 1981 Contempt of Court Act, and I was the first specialist legal affairs broadcast journalist for IRN-LBC, and what did I and my fellow journalists in the corridors of the Old Bailey and Royal Courts of Justice find? Well, day after day, censorship orders on reporting outside the courtroom doors, everything people could hear and see on the inside. Trials, parts of trials, witnesses, judges, lawyers, even people not involved in the cases but mentioned by the way, all gagged, silenced, censored. And when there was a fear the reporting bans could not be made, court hearings went into secret session to cover up incompetence, scandal, negligence, corruption, crimes by police officers, lawyers, and oh yes, even judges. There was no right of appeal, no right at all, which meant courts and judges made orders they did not even have the power to make, and if you breached them, contempt of court for you. To fight all this was going to cost a lot of money and time, lawyers and litigation. Anything in the interest of freedom of the media and the press had a financial cost, which would turn out to be crippling. And in the end, like libel, it's all been given up and surrendered to another chilling effect. When it comes to censoring the media with court orders, our judges, I think, are out of control. But it didn't stop there. Permit me to recall the story of the principal clerk in a government department who didn't want cruise missiles being stored and launched from Greenham Common in some future nuclear Armageddon. She anonymously dropped some photocopies through the letterbox of the Guardian newspaper, indicating the House of Commons was being told some terminological inexactitudes. But we were told not to worry. Section 10 of the Contempt of Court Act was there to protect her and the Guardian and its thoughtful and anxious editor. And my learned friends were sure it would do so and advised accordingly. And Mr. Justice Scott agreed, but then it went before Lord Justices and then Lords of Appeal in ordinary, though I never thought there was anything particularly ordinary about them. Somewhat erroneously, the majority of Her Majesty's judges said, hand over the papers given to you anonymously, or, well, sequestrate your newspaper and everything else the Guardian's Media Trust did socially and commercially. As expected, there had to be a scapegoat, a lightning conductor, and not surprisingly it was going to be a journalist or an editor. In the end it was Peter Preston. He got it in the back, the front, the side, skewered upside, topside and downside. And when I interviewed him, he had more holes in him than a pound of Swiss cheese. And the source turned out to be a mouse, a butterfly to be crushed upon a wheel. She was advised to plead guilty. I would have suggested she pleaded good conscience and took her chances. But either way, mercy and the law were not mutually compatible concepts. And she was jailed for 6 months by a judge called Mr. Justice Cantley, with the nickname Pack Your Toothbrush. What a cruel, disreputable, wretched and unjust course of events. A sordid, repugnant and salutary lesson in the history of journalism, power and the law. My sympathies then and now are with Peter Preston, the Guardian's editor at the time, and of the source he never knew, Sarah Tisdall. And as a young journalist, I knew the future of British journalism would be swimming high swell, cold and grey and angry water. So look out there, a little dab of statute in the ocean of regulating our newspaper media. It's going to do us some good, so they say. Right of reply, regulation with teeth, hacks in the dock and their sources for breaking news-gathering laws without any public interest defences. Doesn't look very promising, does it? I can't see any journalists or editors still with their heads bopping above the water. It's all grey litigation, cold, bracing and sobering liquid law. A few minutes in there and the journalistic exposure, in my opinion, will put hairs on your chest, probably kill you. I don't fancy my chances. Would you be prepared to send your journalism students or your young reporters out there? Jack Kennedy once said, or one of his speechwriters did anyway, we set sail on this new sea because there is knowledge to be gained. Well, on you go then. Breaststroke, butterfly, crawl or backstroke. Best of luck. Give my regards to Neptune. Have a great time singing with the fishes. And please don't forget an old reporting, though oft forgotten cry. Wilkes, Liberty and number 45.